Hello, my name is Megan Brown.
And I'm Selena Lacerna.
We are both outreach officers with the U.S. Department of State's Bureau of Consular Affairs, and today we will be talking about consular notification and access.
One of the responsibilities of the U.S. State Department is to ensure that law enforcement agencies in the United States are aware of and complying with their responsibilities to notify foreign embassies and consulates when they have a foreign national in their custody. These responsibilities are called Consular Notification and Access, or CNA. We recognize that many law enforcement agencies may not arrest foreign nationals on a regular basis and may not be familiar with CNA. By the end of this training, we hope you will understand CNA and why it matters.
So, before we jump into training, I want you to think about what you would do in the following scenario. An adult male British national was arrested for attempting to drive while intoxicated in Glendale, California. The decision is made to take him to a station and hold him in a cell until he sobers up. In this situation, should the arresting officer inform his embassy or consulate? We'll come back to this scenario a bit later in the training. For now, here's a summary of what we will be covering during this training session.
The Bureau of Consular Affairs has no higher priority than to promote the safety and security of U.S. citizens abroad. Across the globe, we serve our fellow citizens during some of their most important moments: births, adoptions, medical emergencies, deaths, arrests, and disasters. We also help U.S. citizens connect with the world by issuing millions of U.S. passports each year. So what is consular notification and access? It's the process of informing a foreign government representative of the arrest, detention, or death of a foreign national, and allowing the government to communicate with its nationals in detention. The foreign government representatives are normally consular officers. Consular officers assist and protect citizens of their own country when those citizens visit a foreign country or live abroad. This is important for all of us as Americans because this is a two-way street. The United States has consular officers in over 200 embassies and consulates around the world to assist U.S. citizens who need help, including when they are detained by foreign authorities. But consular officers can only provide assistance to detained nationals if 1, they know about the detention, and 2, they are allowed access to the detainee by local officials. These procedures are what make up consular notification and access. These consular notification requirements are set forth in numerous international treaties and agreements, most prominently the 1963 Vienna Convention on Consular Relations, a multilateral treaty to which the United States and more than 170 other countries are party. These treaties are binding on federal, state, and local government officials. In other words, they are the law.
Why do we go to such great lengths to ensure we are complying with these procedures here in the United States? As I mentioned, not only are we a nation that meets our legal obligations, but by doing so, we help ensure that Americans abroad receive the same consideration from foreign governments. Millions of U.S. citizens travel and work abroad every year. If they are arrested, U.S. citizens rely upon the U.S. State Department through our consular officers posted overseas to assist them. To do that, U.S. consular officers need to be notified and have access to those arrested to ensure that they have adequate food and medical care, are able to contact their family, and have access to an attorney. If you remember only one thing from today's presentation, let it be this: the way we treat foreign nationals detained here in the United States can and does affect the treatment that U.S. citizens receive when they are arrested abroad. That is absolutely crucial to understanding why we must carry out CNA procedures domestically. Under these international treaties that contain CNA requirements, U.S. citizens detained abroad have the ability to have a U.S. consular officer notified of their arrest. But U.S. citizens in that situation may not know about this option unless the arresting officer tells them. The same goes for foreigners arrested here. Not every foreign traveler knows that they can request that their embassy be contacted. Somebody has to tell them. That would be the officer who arrests them, which could be you. Honoring our obligations here at home is important for the safety of Americans abroad. Consular notification and access obligations apply to all foreign nationals in the United States. So, who is a foreign national for CNA purposes? Well, it's any person who is not a U.S. citizen. This includes short-term visitors, lawful permanent residents or green card holders, and undocumented foreign nationals. By the way, many U.S. citizens also have another nationality. Consular notification and access obligations technically do not apply to dual national U.S. citizens. However, for dual nationals, we still ask that you notify the consul of the other country as a courtesy. Our U.S. embassies abroad want to be notified when U.S. citizens who are dual nationals are arrested in any other country, so we need to do it here to expect that from authorities abroad. A consular officer is an official of a foreign government accredited by the U.S. Department of State and authorized to provide assistance to that government's citizens in another country, regardless of whether a consular officer is assigned to an embassy in Washington, D.C., or to a consular office maintained by the foreign government at another location in the United States.
What are the CNA requirements when you arrest or detain a foreign national? It depends on the treaty that we have with each country. There are 58 mandatory notification countries. For foreign nationals from these 58 countries, notification to the foreign government's consular officer must be made whether the arrestee wants it or not. If the detainee asks you not to make the notification, you should explain that you have no choice. It's a legal requirement. The notification requirement should still be honored if a detainee has applied for asylum, but in that situation, you should not disclose any information related to the asylum application to the foreign embassy or consulate. If a foreign government's consular officer insists that they are entitled to information about a detainee that the detainee does not want disclosed, please contact the State Department for guidance. For all other countries, the requirement is that you must offer to notify the arrested foreign national's consulate. The arrestee can accept or turn it down. Keep a record of the person's response. This is important in the event there is any question regarding consular notification. One common misconception: allowing an arrested or detained foreign national to call his or her consular officer does not qualify as consular notification. Notification must be made by the arresting or detaining law enforcement authority to fulfill treaty requirements. Now, for the notification procedure. Notification must be offered and/or made within 24 to 72 hours after the initial arrest. Even if the national is only detained for a few hours, go ahead and make or offer notification. It's better to be safe than sorry. And if the foreign national has been arrested for an offense where it's obvious he or she isn't going to be released anytime soon, go ahead and make or offer notification as soon as you can. You are not required to comply with consular notification requirements for making momentary stops, like writing a speeding ticket. In that scenario, you're not arresting the individual or requiring them to go with you to a place where they will be held or detained. So, going back to the scenario of the intoxicated British national we mentioned at the beginning of the session. Now that we have discussed when to notify, you can probably guess what you should do. Because you took him to the police station to sober up, and since the United Kingdom is a mandatory notification country, you should notify the United Kingdom Embassy or the nearest consulate, even if the individual will be released after a few hours. As for how you notify the consul, we list contact information for all foreign embassies and consulates in the United States on our website, which we'll provide the link for later. Believe it or not, the fax machine works 24/7, and the fax confirmation sheet provides a written record of notification. You can alternatively provide notification by email to most foreign embassies, and the copy of the notification email that you've sent is also a good written record that you've sent notification, and it also works 24/7. Keeping good records is critical. In the event the detainee's attorney, or foreign government later claims that no offer to make consular notification was made, or that notification never happened, your records will provide proof. If you notify in any other way than by fax or email, such as by telephone, make a note in the arrestee's file of the time, date, phone number you called, and the name of the person you spoke with.
Here is a list of the 58 mandatory notification countries we've mentioned. If you are aware of anyone entering into your custody that is from one of these countries, ensure during intake that they have been made aware of CNA and that by law you will notify their embassy or nearest consulate that they are now in your facility, whether they want you to or not. The foreign national does not get a choice in this. If the foreign national is not from a mandatory notification country, you must offer to notify their nearest embassy or consulate. If they ask you to notify, you must do so. In addition to arrest or detentions, consular notification and access obligations are also triggered in the following situations. When a foreign national dies, when a foreign national minor or incapacitated adult in custody requires a court-appointed guardian. This would include minors being placed in foster care or vulnerable adults, including ones experiencing dementia or experiencing severe mental health crisis, and when there is a plane crash or shipwreck in U.S. territory or in U.S. waters. In the case of serious accidents or major disasters, the competent authority who needs to make notification will vary, but officers who find themselves responding to such incidents should make every effort to ensure that notification is provided. Though serious injuries are not specifically covered in the Vienna Convention on Consular Relations, the Department of State encourages U.S. officials to make notification in any situation where a foreign national is in such a critical condition that they cannot communicate for themselves, and contacting consular officials would be in that person's best interest. For example, if they are in a coma, ICU, etc. Notification in the situations I have just described should be provided in the same way as notification of an arrest or detention, so by fax, email, or phone.
Consular notification and access obligation provide consular officials with the right to have access to their nationals. They can visit, call, or write. Whether they choose to do so and how they choose to do it depends on the traditions and resources of the country and the location of the nearest consulate. Some of the services that consular officers provide for their nationals are listed here. Consular officers are expected to follow the regulations of the detention facility regarding security in the time, place, and manner of their visits, but the regulations should not be so strict as to prevent consular access. We urge authorities to grant consular officers liberal access to detained persons, providing them every courtesy consistent with local laws and regulations. Liberal visiting privileges are particularly important when consular officers have to travel long distances to visit their citizens. Remember, reciprocity. What access conditions would you like the U.S. consular officer to have if visiting a relative of yours being detained in a jail overseas? Foreign consular officers are not permitted to practice law in the United States, but they should be given the same communication privileges as defense attorneys. Consular officers may not interfere with a criminal investigation or judicial process. It is not necessary to delay an interview or interrogation to make consular notification or to wait for a consul's arrival.
We realize that some law enforcement departments might interact with foreign diplomats more often than others. The State Department's Office of Foreign Missions, or OFM for short, is responsible for the issuance of all diplomatic ID cards, driver's license, and vehicle plates. On our website, we have provided you with a short video dispelling the most common myths about law enforcement interactions with diplomats and their family members. If you have more questions regarding diplomatic immunity, validation of identification, or anything to do with diplomatic interactions after watching the OFM video, please contact OFM. Their contact information will be listed at the end of this presentation.
Finally, why should you care about all of this? Simply put, it is the law. The Supremacy Clause in Article 6 of the U.S. Constitution makes CNA the law of the land. We want to uphold our international agreements so that we can protect U.S. citizens overseas. If we comply with our international agreements, other countries are more likely to do so. CNA compliance helps avoid legal challenges. Defense attorneys may attempt to challenge prosecutions based on failure to provide consular notification. Some judges may find that the appropriate remedy for a CNA violation is to have evidence suppressed or convictions overturned. Some U.S. states are instituting legal remedies in the event of the lack of consular notification. Massachusetts provides for a new trial if lack of notification is seen by the judge as prejudicial against the foreign national's case. California, Oregon, and Illinois also have consular notification laws. Why take the chance on this? Following CNA procedures is easy, and keeping records of notification avoids creating grounds for challenges of convictions and sentences. Also, foreign consular officers can help you. They know the language and the culture of their nationals, can contact relatives, and be a resource for you. Your efforts are critical to protecting U.S. citizens overseas. When we have trouble with a host government, we can honestly point to your hard work in making sure that country citizens are given proper consular notification and access in the United States. Our CNA materials are available on our website, travel.state.gov/CNA, including the manual, notification flowchart, and a poster with the mandatory statements in several languages.
Here is what our website, travel.state.gov/CNA, looks like. This is your one-stop shop for all things CNA. The most frequently visited section of our website is the contact information for embassies and consulates. In addition, there are PDF versions of the consular notification statement in 20 of the most spoken languages in case the detainee does not speak English.
Thank you for your attention today. You each play a vital role in ensuring that we comply with consular notification and access obligations, which protect U.S. citizens who travel and live abroad.
Here are the ways that you can contact us if you need additional information or guidance. Our email is consnot@state.gov. The consnot is short for consular notification. Please write down the ways to reach us if you have additional questions, would like to request additional training, or want copies of our information and guidance mailed to the locations you serve. OFM's contact information is also listed here in case you have questions regarding foreign diplomats.